Hi, I'm Josh Stevens of Partner McMurray and Shuster, and I'd like to welcome you today to our Privacy Watch series webinar, Legislative Shakeups and Enforcement Hotspots. Before we get started, a couple housekeeping notes while folks are rolling in here at the top of the hour. First, this webinar is being recorded and will be available online probably sometime next week. So if you are using an AI note taker to try to capture everything we talk about today, we would ask that you disengage that note taker to ensure a welcoming environment for all attendees. And if you want to go back and reference the webinar, use the recording that we're going to make available. Also, just, we like to take questions during our presentations. We received a few beforehand that we're going to try to get to during the course of the hour. But if you have any questions as we go along, please do put those in the Q&A box. We'll try to get to as many of those as we can. And if we can't, we'll follow up with you later. I'm joined today by my esteemed partner and guru on all things regulatory, Michele Shuster, who is going to be providing us a ton of insights today. And as we get started, just a reminder, we are going to be talking in generalities. This is an educational seminar. This is not an attorney-client privileged communication. This is not intended as legal advice. Facts matter when it comes to privacy issues. So take whatever we say with a bit of a grain of salt, for the simple fact that your facts might be slightly different than some of the scenarios that we're discussing today. As we get going here, I think Michele might have some breaking news to update us on. And so, Michele, I'm going to turn it over to you.
Well, I think the breaking news actually is, Josh, that you invited me to your webinar series today. I think it's been at least a year, maybe a year and a half. And okay, I don't remember all of the details of what I said last time, but I think I was pretty good. Maybe I'd get an invite
You're
sooner than a year
awesome,
and a half.
Michele, as always.
No, seriously. Thanks for having me today, Josh. It's always fun to present with you. But we do have some breaking news. It has been a really interesting year in administrative law, and I never thought I would say that sentence. But as you recall, at the beginning of the year, we had the Supreme Court case that overturned the Chevron deference standard, and I'm going to come back to that in a second. And then this week we had the Supreme Court overturning the Hobbs Act. And what those two things have in common is that they both contained provisions that required district courts to basically take as the law any of the orders or rules that the agencies had passed. And primarily we're talking about the Federal Communications Commissions here. And the Hobbs Act applies specifically to the Federal Communications Commission. Chevron deference was a little bit broader. But the point of all of this is, as those of you that are in the direct marketing area and engage in texts and telephone calls and faxes as means of marketing, then this has an effect on you, because in the world of the communications law, especially the TCPA, one of the things that we could count on was the interpretations from the FCC. It gave a certain level of certainty in this area. And we can talk about a number of those ways, and we'll be having another webinar on this. But what the Supreme Court said, and this is the second time they've said it, is that you cannot tie a court's hands with an administrative agency's ruling or interpretation. The courts have to be independent bodies that can evaluate the circumstances and facts of a case and then make their own independent decision. And with the Hobbs Act, which is a statute that had been in place since, the early 1900s, it was put in place because of some of the racketeering behavior that was going on during the Prohibition era. And the FCC needed to be able to respond very quickly to those types of things. So the Hobbs Act was put in place so that the FCC could determine very quickly that things were in violation of the statutes that they were enforcing. So anyway, the point of this is there are things that we have put out there as semi-binding, at least binding to the district court level. The appellate courts were always able to review that. But some of those things, for instance, prior express consent, that is not in the TCPA statute. And what the Supreme Court looked at when reviewing the Hobbs Act is and with Chevron deference was what is in the statute that Congress passed? And then what authorities do they delegate to that administrative agency to pass rules? And then the Supreme Court now has said twice that agency has to stay within its statutory grant of authority. And for instance, with a prior express written consent to make certain types of telephone calls using an automated dialer, basically for informational types of calls, you could rely on a consumer providing their telephone number, a means of contacting them, and then contacting them, and that means, and that would be prior express consent because it's not otherwise defined in the statute. So just one area to look at. We'll be talking a lot more about this in the next couple of weeks, so stay tuned. So that's our exciting breaking news this week. It seems like there's always something that we didn't plan on, Josh, when we plan these webinars.
There really is. I feel like we should maybe have a webinar a week of just what happened this week.
Oh, be careful what you ask for. I'm pretty sure our marketing director is on this call. The other thing, though, just before we start, Josh, I would be really interested in getting this kind of feedback from the people that are attending today. If you're watching this later, feel free to send us an email. You know, based on everything that we're seeing right now in the privacy world in particular, that you're going to be primarily talking about today, you know, what does the audience see as the future of direct marketing? It's becoming much more difficult. And I'm going to ask you the same question at the end, Josh, what you see for the future of direct marketing and in compliance with all these regulations. So think about that. And if you already have given it a lot of thought, go ahead and share it with us, and we'll share most of them probably at the end.
Yeah, it's a changing world out there, and I think for a lot of businesses trying to keep up with it is well, headache might be a nice way of framing it. A real challenge could be maybe a more accurate way. So with that, yeah, let's talk about these privacy laws and what it looks like in America today. And if you've been watching our Privacy Watch series over the years or other webinars we've done, you have watched the map that's on this screen get filled in over these last about 5 years. What started with California in 2020 has now really spread across the country. And one of the things that always jumps out to me when I look at this map is how it's not a red state or blue state issue. We often think about regulation as well, blue states have a lot of regulations and red states have few regulations. And it's an interesting ordering principle in our minds. But when it comes to privacy, this is a bipartisan issue. There are states across the political spectrum that are trying to wrestle with how to protect consumer privacy in a way that still enables businesses to operate, but make sure that consumers are protected. Here on the map, you see the states in green have comprehensive consumer privacy laws already in effect. The states in this, we'll call it orange, a darker orange, and then almost a brown orange. I don't know why we went Irish colors, but we did, are coming into effect over the coming months. And they really are coast to coast from New Hampshire to California. And one of the things that I expected to see in 2025, and this is why I don't go to Vegas and cast bets, was that we would actually have more states passing comprehensive privacy laws this year, not just states that had already passed them coming into effect. That hasn't really happened. There are two states that are the farthest along in the legislative process. Oklahoma with Senate Bill 546 that passed the state Senate. It's in a House committee, but it hasn't gone anywhere since April. Similar story in Vermont with Senate Bill 71. Passed the Senate in a House committee and is sort of stalled out. And this really raises a question in my mind, and Michele, I'd love to get your thoughts on this of, you know, is everyone just waiting to see what happens nationally at the federal level? And what is it like in your experience when there are issues where states are trying to deal with them and maybe the federal government's trying to deal with them too, and they're all jostling to figure out what to do?
Well, I think in today's atmosphere and environment, there is no normal. And so there is no usual. And so I feel like the whole playbook has been thrown out, and that things are not as they used to be. Although one thing I would say is I think it's very and mostly because I hear it from you as well, Josh, very unlikely that we'll see a federal privacy bill. I remember having conversations with some of the folks at the FTC who were starting to look at drafting a privacy rule. Gosh, it has to have been 6 or 7 years ago now. And I remember asking them what they thought the possibility of successfully getting that rule through. And they didn't respond, but there was just a shake of the head. So I don't know that that's changed much. I think that the federal government is focused on other things right now. I think that legislatively, there are some complicated issues that are going on, and I don't know if there's much of an appetite right now to try to take on a privacy statute. And the FTC trying to get a privacy rule in place, I think would be even more difficult at this point. So yeah, I think it not likely, and I think we'll continue to see states moving forward, although slowly it seems at this point.
Yeah, and I agree with that, Michelle. And the other thing I would mention is we have to remember that Congress only has so much bandwidth. And right now, what has been deemed the big beautiful bill, I think is the title of it. This budget bill that's working its way through is certainly consuming that bandwidth. Once that passes, perhaps maybe there will be more room to tackle other issues. But
Yeah.
at least at the current state, it seems like all the oxygen is getting sucked out of the room for Congress by some of these more budget or immigration or national security kind of issues, as opposed to trying to tackle a thorny privacy issue.
Yeah. And I think even if they did, unless it had a preemption of the state laws, I don't think it would be much good. It would just be an additional layer of regulation. So I think trying to get a bill with preemption in it right now would be even more difficult.
Yeah, and the California delegation, which is what, 50-ish members, I think, in the House, has been pretty adamant that they're not going to support a bill with preemption because that then ties their hand to be that, laboratory of the state
Yeah.
and advance privacy as they see fit. And
Else we will soon discuss.
yes, how you overcome that, who knows? Um, so
Yeah, I
now,
agree.
while a full new comprehensive privacy law hasn't passed yet this year, we have actually seen quite a bit of legislative action in other ways. So I'm going to run through a few of those for you right now. The first is with the GLBA exemption. So in these comprehensive privacy laws, generally speaking, they exempt either data that is subject to the Gramm-Leach-Bliley Act, or they exempt entities that are subject to the Gramm-Leach-Bliley Act. Now, an entity-based exemption is the rarer of the two. But what has happened is some regulators have realized that this potentially creates a loophole where data that is processed by a GLBA covered entity but falls outside of GLBA itself is now left unprotected. And so we've seen legislative action to convert some of those entity exemptions into data-based exemptions. Montana Senate Bill 297, for example, did just that. It comes into effect October 1st. And so if you are a financial institution who didn't worry about Montana because you had that GLBA entity exemption, now you're going to have to do a more nuanced approach, focusing on exempting only GLBA covered data. In Connecticut, Senate Bill 1295 would do the same. This bill passed and was sent to the governor on June 23rd. If it is signed, it'll largely come into effect July 1st, 2026. This is an omnibus bill, though, so it does a whole lot of stuff, even outside of privacy. It's a very lengthy bill. But in the privacy world, in addition to converting that GLBA entity exemption into a database exemption, it also would lower the threshold for businesses to be subject to Connecticut's privacy law. Currently, generally speaking, you need about 100,000 Connecticut residents' data in order to be subject to the law. That threshold's a little lower if you sell data. As you can see here on the screen, They're broadening out that applicability to capture more businesses. One of the really interesting things that caught my eye is that it has this unique requirement in a privacy policy that you disclose if you collect, use, or sell PI to train large language models. This is obviously a direct attempt to tackle the AI issue of consumer data being used to train AI systems and consumers being unaware of that. So if you do use data in that way, you're going to need to update your privacy policy. It also gives consumers a right to obtain a list of third parties to whom their data is sold. This is similar to an existing right in Oregon and Minnesota. You can't sell sensitive PI without consent. That also now aligns with several other states. So you can see a bit of a trend here where Connecticut, which was one of the first states out the gate with a privacy law, is now reacting and adjusting to some of the trends from the newer states. And then what I think is going to have a dramatic impact for a lot of businesses, there's an outright prohibition on the sale and sharing meaning for cross-context behavioral targeted advertising of PI of consumers under the age of 18. So it's not even just you got to get consent to do it, it's you can't do it. And so businesses that engage in data sales of minors' data, this could be a big blow coming out of Connecticut. So we'll see if the governor signs it. There is a possibility it could get vetoed, but if it is signed, this is going to be pretty dramatic. And along those lines, Oregon as well has made several amendments to tighten their privacy law through Oregon House Bill 2008. And like Connecticut, with putting in a prohibition on the sale of minors' data, Oregon's done a similar thing, but for under 16s. And so if a business knows or should know that those consumers are under that age, they can't use their data for targeted advertising, profiling with legal or similarly significant impacts, or to sell that data. Notably, though, the bill also prohibits the selling of precise geolocation data, regardless of age. And I suspect this may be a reaction to some of the investigations that have occurred around vehicles and insurance companies, and you saw this come out of some states, and particularly also around mobile devices. We often hear about the flashlight app that collects your precise geolocation. Why does it need to do that? Well, it's doing that because they're selling that data. It doesn't actually need to be done to provide you a flashlight, right? And so Oregon's saying, no, we're just gonna quash that, and you cannot sell precise geolocation data. And again, there's no consent exemption. They removed that. So starting January 1, 2026, if you sell precise geolocation data of Oregonians, you're gonna be in trouble. And then New Jersey has proposed a set of regulations. Now, these are open for comment through August 1st. And Michele, I would love, before I get into it, could you talk a little bit about the notice and comment process and how important that is for businesses to engage with?
Yeah, really so important. And we frequently get involved with our clients in providing comments to proposed regulations. And there have been several that have gone into effect recently that we really wish more would have proposed comments on. But this is the one opportunity really for companies to provide their input and insight to regulators about what the potential effects of a regulation could be on their company, or even broader than that, on the industry. And when you think about it, I can tell you from having been in the AG's office that the folks that are often the experts that are providing that kind of first draft of most of these types of regulations, they've never been business owners. A lot of them haven't been in retail jobs, except maybe in restaurants when they were in school. But they don't have that perspective that you do from being in a business day in and day out. So, how this works is there is a notice of proposed regulation usually, and they will give a certain period of time to provide comments, and then those comments close. Sometimes they'll open up those up again, but you should never count on that. The ability to provide specific industry input to those proposed regulations is so critical, because I see time after time where those regulators have taken that into effect when they are putting together the final versions of regulations. I would also say, in submitting those, I really recommend people go and visit however that regulatory body is, so they're not just getting a document that I'm sure we've all tried to make very exciting, but getting that actual experience from the people who are in the industry face to face is really invaluable. And a lot of times in those meetings, you see that the regulators had never given any consideration to these types of specifics, and really critical to provide that. Once the regulation is drafted, sometimes they will open up those comment periods again upon a final draft, but again, you shouldn't take that as a given.
Yeah, and we have seen with clients that we've assisted, we have seen success in helping shape those regulations. And it's not that the regulator will always agree with you, but sometimes they will, or that you've given them an insight, right? To Michele, like to your point about they haven't necessarily been in the industry so well. We all know how things sometimes sound better on paper and in theory, but then when the rubber meets the road, the actual nuances of trying to put that into practice are very different and make it much more difficult. And so being able to help educate regulators so they're aware of that is critical. And I also really like, and not all regulators are great about this, but sometimes you will actually see when they implement the final regulations, they'll have commentary and they'll say, we got comments from ABC that said XYZ, here's why or why not we made a change based on that.
Yeah.
And that also provides valuable insight into how they're thinking about the regulation that they're promulgating, because now they're addressing the concern that was raised directly and explaining how they're thinking about that concern.
Yeah, really valuable insight before, while you're looking to put a compliance regime in place around any types of new regulations. I'd also say a lot of trade associations out there do get involved in that type of comment period. We have seen the IMC, the Insurance Marketing Coalition, be extremely successful lately with some of the stuff that they've been doing. So, reach out if you don't believe it's right for your company to do that. Reach out to your trade associations, provide that insight, and they will frequently get involved in those types of things.
Mm-hmm. Yeah. So speaking of these regulations here in New Jersey, though, they're a doozy. They are lengthy. And while you can definitely see the influence of the California regulations and the Colorado regulations that were previously issued in those states, New Jersey does have a few unique twists to what they're proposing. And I've got a few of them here on the screen, but I'll just run through these real quick. The first is around AI again. We can see there's regulatory nervousness around AI and what that means for consumers. And so the way New Jersey's tackling this is, while their privacy law usually allows the use of personal information for internal research and development and improvement purposes, if that is to train AI, you can't do it unless the consumer consents. And so this is, again, trying to make sure consumers know when their information is feeding into these AI systems. In what may be a callback to a bygone era, New Jersey is actually requiring that all your privacy disclosures, notifications, and communications must be printable. They have to be able to be reproducible on paper. And I kind of got a little bit of a chuckle out of this as a millennial, I will say. However, I'm also a millennial who still prints a lot of stuff. So I guess in that sense, I see it. But this goes to how you format things on your website. We often see privacy notices these days that use these, what are sometimes referred to as like an accordion structure, where you click these little things and they open up a box, and you click a thing and it opens another box. And so that's all well and good from an ease of reading perspective online, but that may not be easily printable. And so you have to think about those design choices if these regulations go into effect. Another thing that's kind of interesting is they actually are going to require that you test your methods for obtaining consent and submitting consumer rights requests to make sure that they work and that they don't obfuscate the ability of the consumer to exercise those rights. Michelle's going to talk here in a minute about some stuff we've seen come out of California, but this kind of touches on a similar issue of if you have something in place, it has to work. And New Jersey is now saying, yeah, you got to test it. You got to make sure it works. They're also looking at enhancing loyalty program disclosures. So if you operate a consumer loyalty program, this will be something to pay attention to. Making it clear that records related to consumer rights requests have to be kept for 24 months at least. And they're actually itemizing the records you need to keep, which is helpful to know what it is you have to maintain related to those rights requests and what you can possibly get rid of. And then the last one I'll just highlight here is about revoking consent. Remember that under these consumer privacy laws, if a consumer can give consent, they have to be able to freely revoke that consent. And in New Jersey, the regulations say that that revocation has to be as accessible and user-friendly as how they give consent. Well, this could be a challenge for a lot of businesses because if you make it where they can click one little checkbox and hit submit, and now they've given a consent, you got to think about when they go to revoke that, how do you make that one little checkbox and hitting another button? That could be really tough for businesses to handle. Also, consent will expire in 24 months if the consumer hasn't interacted with the business in that time period. So trying to keep track of that and be able to demonstrate when was the last interaction you had with the consumer could be a significant challenge as well. And so with that, I'm going to turn it over to Michele here to talk about some recent enforcement activity that we've seen out of California.
Yeah. And I have to tell you, I thought it was kind of funny that we're doing this over the lunch hour and you've given the title California on a Roll for this slide. And I don't know what kind of sandwich that would be. But
I was thinking more the sushi roll,
the
the California roll.
See that you'd be sushi, I'd be thinking deli about that. But anyway, so California has been on a roll. So now that the CPPA is up and active and aggressively, I would say, investigating and issuing orders out of that office. There are some common themes that we're seeing come out, and we'll be talking about the Todd Snyder order that came out here very recently. But the things that the CCPA are focusing on are the requirement that a consumer provide an ID verification to exercise certain types of rights. And it's really important under the California law to understand which requests you are capable of verifying, and then the ones that are non-verifiable types of request, and understanding the distinction, because California is really looking for those websites that are requesting more information than is required to exercise a consumer privacy right. Also, the do not share implementation issues that they're seeing out there, and in this Todd Snyderman enforcement order, I kind of feel sorry for the company. It's a retail company, has a retail locations in California. And they were using an industry standard for cookie management and accepting those do not share requests, and it malfunctioned. And even though it was not that company's fault for the malfunction, the CPPA said very clearly, it doesn't matter that it wasn't your technology, you're using that technology, and you're responsible for making sure that it functions properly. So it's really a message that they wanted to get out there. You just don't slap on this, software onto your websites, assume it's going to work. You have to test it. Also with contracting, as you're probably aware, California requires some very specific contract terms. They're required by the regulations. You need to make sure that your contracts have those, especially for those companies that you are sharing information with, and ensuring that those contracts meet those requirements. And then, this is just so critical with all compliance. And even if it's not in the regulations, we would say this would be a requirement. The training is so important, especially, you guys are all here on this webinar today or are watching it later. So you're getting that training. And then making sure that those that are responsible for enforcing are responsible for implementing the compliance program for privacy, that you are providing them with this information. And so if you want to go to the next slide. And Josh, I think this one's yours.
Yeah, and so, we were just talking about regulations and providing comments and all of that. California actually has two regulatory proceedings going on right now. The first is around automated decision-making technology and also just a variety of other updates to the existing CCPA regulations. This rulemaking has been very controversial. And in fact, we have seen the governor get involved in pushing back a bit on what the agency was initially proposing. The board of the agency pushed back on the staff to go have them modify some things and make revisions because California is really trying to walk this line between protecting consumers around the use of AI, which is essentially what automated decision-making technology is, right? While also being an innovative and leading state in the development of AI. And so it's a very fine line that they're trying to navigate here. And so this rulemaking has had multiple comment windows. Michele, you mentioned how sometimes they'll reopen, right? I think they've had maybe 3 rounds of comments that it's, pardon me, I'm getting over a cold, so I've still got a little cough that sneaks up on me every now and then.
I just thought you were getting choked up about comment periods, but that makes way more sense. Okay.
I do love a good set of comments.
I know you do.
But so June 2nd was when the most recent window closed. So we'll be waiting to see what comes of that, what further revisions they make in the next draft that will get submitted to the board. If you watch the CPPA website, they're actually really good about publishing the agenda of their board meetings and what documents they're going to present to the board. So you can really keep a good pulse on how their rulemakings are proceeding. And I would encourage you, if you're a privacy practitioner, to do that, check that out, and get a flavor for what they're trying to do. The other rulemaking that's in progress is for what's called the drop system, the delete request and opt-out platform. This is for data brokers. What it would do is if a California consumer wants their personal information deleted from data brokers, instead of having to go to each data broker separately, they could file a request with the agency, and then the agency would feed that out to all registered data brokers through this drop system, and registered data brokers would be required to connect to the drop system and receive requests through that system. So this is intended as a way to make it easier for consumers to make those requests. This is also why the annual fee to be a registered data broker in California jumped from $400 last year to $6,600 this year, because they are funding the development of this system entirely off of data broker registration fees. So the comments on this closed June 10th. This one's probably less controversial, more technical, right? Because it's about how this system is going to operate and feed information back and forth, but still something to watch if you're a data broker, because you'll need to connect to this system. And so you'll need to know what those technical requirements are. And in addition to California, Texas has been on a roll over the past year or two. I think Texas has decided, they've made some public statements that they want to be a national leader in privacy. And so they have really staffed up in the Texas AG's office, their privacy unit, and they've taken on some, I guess we could call them high profile cases, couldn't we, Michele?
Yeah, for sure.
To try to get their name out there. The first that I'll highlight here is a lawsuit they filed against General Motors. They are alleging that GM was selling vehicle driving behavior data to third parties without clear disclosure to consumers. It's an interesting case, and I think for anybody who owns a car, it's just an interesting topic. If you go read the complaint, obviously it's being vigorously litigated, and we'll see how that ends up shaking out. But I think the takeaway from it is the importance of consumer disclosure. So if we are, and again, this is not saying that GM actually did or didn't do anything that's alleged in the complaint, but if you are a business that's processing personal information, consumers need to be aware of what you're doing with that information. So having those consumer disclosures is key. I know it sounds basic, but it really is key. This second big lawsuit that I'll highlight is one against Allstate and some related companies to it, some tech companies that they owned or invested in. I'm not entirely sure on the exact structure of the relationship there. But what the tech companies did is they had an SDK, a software development kit that could be programmed into applications that would allow the collection of data around like the movement of the device or different information that could then be used by insurance companies in connection with rating decisions or discount programs or things like that. And this data collection was occurring by a third-party apps. So it wasn't that the tech company's app itself was collecting information without disclosure. It's that their technology was embedded in other applications and was collecting this information through those applications and using it for these purposes without privacy notices or informed consent when consent was needed in ways for consumers to exercise those privacy rights. Those consumers would have no idea generally that this data collection was occurring. What was interesting about this case to me is this angle of software being embedded in a third-party application and that software provider being on the hook for the data collection that they were doing through that third-party application and not the third-party application itself being on the hook. So it's an interesting angle on liability. And so if you're a company that develops software that gets embedded in other applications, it's definitely something to think about and work through. How do you ensure that that's being done in a compliant way? Texas also announced recently a settlement with Google in the over $1 billion range. Huge press because of huge numbers, also because it's Google and anything with Google attracts eyeballs. But this this settlement was actually not so much under their privacy law, but under their UDAP statutes. And Michele, I'm gonna ask you a question here in just a second about UDAP and kind of the space. But what was interesting about this with Google is they were alleging all of this kind of tracking and monitoring that was going on without consumers knowing it. In fact, sometimes consumers, like in the case of incognito mode, affirmatively thinking that they weren't being tracked, and then they were. And so this kind of deception angle going on. And so Michele, I think we talk about these privacy laws a lot, and we forget to talk about UDAP and
Yeah.
and its impact. And so I was wondering if you could talk about that for just a second of, even when we don't have a privacy law in a state, how these UDAP frameworks are still really important.
Yeah, yeah. So UDAP stands for Unfair Deceptive Acts or Practices. It's a term that probably first came about in Section 5 of the FTC Act, which broadly prohibits a company from engaging in any unfair or deceptive acts and practices in a consumer transaction. And so we have that at the federal level with the FTC, and then every state AG's office has enforcement power. I should take that back. There are a few governor's offices that it's in as well, and one Department of Agriculture. But in general, we'll just say AGs, and no, I mean the broader group too. They have enforcement authority under the state's UDAP statute. And so it's something you really need to be aware of. Those statutes were specifically drafted to be remedial, meaning that it wasn't possible to define all things in the future that might be unfair or deceptive. So they are so broad, which is why you see them brought into all of these other areas of the law, like privacy law, because it's a very easy way for regulators that don't have a specific new law that they can act under to go back and say, well, you made these promises to the consumers about how their information would be handled, or that it would be deleted, or that it would be secure, all of those things, or any of those things. And then in reality, that wasn't occurring, or there was some type of mishap that made it so it was no longer true. So really important to understand that even beyond the privacy laws and really in all areas, when you're involved with consumers, there are these very remedial statutes that could apply. I know most companies, the ones we work with anyway, they really want to make sure that the things that they promise to consumers, they deliver. And that's really fundamentally what's at the bottom of this. But there are times where, something like this might happen, where you have tracking software that was told that it would honor specific requests from the consumers, and then because of a malfunction, it doesn't. And it doesn't matter if you intended to violate the statute or not. It is a strict liability statute. The good news is a lot of these regulations don't have, I can't believe I'm putting it this way. One thing you should know about these regulations is that most of them don't have private rights of actions for consumers. Most of these are regulatory actions by the AGs for when it comes to monetary relief. So different from some of the other statutes that we see out there.
Yeah. Yeah. And as we think about just a couple other quick enforcement priorities, and then we'll talk about enforcement actions, I think that interfacing with the regulator component is really critical. So just a couple quick hits here as we're maybe running a little short on time, where we're going to pick up the pace a smidge. De-identification, if you are de-identifying personal information so that you can use it in a broader way than you could use personal information, remember that California has some specific rules around de-identification and commitments you have to make related to that. So ensure that you're following those. This is an area that we're seeing California getting interested in. Lastly, as I mentioned with data brokers, California is doing a lot with them. Oregon's doing a lot. Texas has sent over 100 warning letters to data brokers. If you engage in the sale of data, you need to do a data broker analysis to see if you fall within the definition of a state's data broker law. There are about a half dozen states that have these. Failure to register can come with steep fines, and California recently narrowed an exemption for when businesses have a direct relationship to the consumer in a way that I think is going to catch a lot of businesses who don't think they're data brokers off guard, because it puts not only a time limit, so essentially the consumer has to have interacted with you in the last 3 years, but also a categorical limit in that only the data you collected directly from the consumer is exempt. If you brought in any third-party data that you're then selling, that would not be exempt. And so if you are engaging in any sort of data sales, definitely you're going to want to do that data broker analysis. So let's say something happens. Oh, sorry, I forgot Oregon. Can't believe I forgot Oregon. Such a nice state. So just quickly with Oregon, they have stood up their privacy unit in the AG's office. They've been very busy. In the first 6 months of enforcement, they've sent out 21 what they call cure letters. Essentially, these are letters informing businesses that there are some issues and asking them to take remediation steps to fix those. Most commonly, these have been around Oregon-specific issues, like having a list of states in your privacy policy that have consumer rights and not listing Oregon, or failing to disclose to consumers that they can get that list of third parties to whom their data has been sold, or kind of along the California trend of inadequate or burdensome rights mechanisms. But what's nice is Oregon's been reaching out and businesses have been responding. They've been taking steps to fix these problems. Starting January 1st, Oregon will no longer be required to do this kind of preemptive reach out before they start an enforcement action. They can, it's at their discretion, but they'll no longer be required to do that. So if you've still got some gaps in your compliance program when it comes to Oregon, you're going to want to get those buttoned up before January 1st. And so, Michele, when a regulator does come knocking, what does that actually look like?
I think it's scary for most people is probably what it looks like. But so, what generally how these types of things start, it's a civil investigative demand, which is the regulator speak for a subpoena, and the civil investigative demand, or CID, will say that we have reason to believe that you have engaged in some practice that violates some law, therefore requesting that you provide us with this information. They'll cite their subpoena authority under basically their UDAP statute is usually where that's found, could be in the privacy statute here as well, that you are required to provide answers to that subpoena. And usually it's in the form of answering questions and providing documents. And these requests are usually extremely broad. And so the first thing I would say, it's really critical to get counsel that is knowledgeable in this area, because you need to know what's kind of the standard for, I'll call it pushback on the regulators, as to what is reasonable to be asking for at this point. You can do things like limit the scope, but either by time, or if it's for emails, maybe only specific email boxes for a specific person. It could be that you ask that you could provide an answer later after they get through the first tranche of information that's provided, because maybe then it won't be necessary. But there are a number of different ways that you can, attorney-client privilege documents, that one I really want to make sure. You would not believe the times that I have heard stories where attorney-client privilege documents are mistakenly sent to a regulator's office. And while you always say that you're not waiving attorney-client privilege for something like that, it doesn't matter. The AG's office already has the information, and usually those types of documents are very sensitive. So again, going back to really critical about how you respond to these types of things. So it will say you've responded to a civil investigative demand. The next thing that happens is usually what we will do is to continue to have that dialogue with the AG's office, explain to them the type of materials that we're providing, what they're likely to find there, and usually why this isn't a violation, or if there's a technical violation, why this shouldn't lead to an enforcement action, those types of things. The regulators are almost always open to those conversations. Important to keep those lines of communication open. And at the end of the process of the AG reviewing it, one of two things is, well, actually just one of three things could happen. One, you don't hear from them for a while. Two, it could be they communicate to you that they've reviewed the information, they've decided it's not necessary to take an enforcement action at this time, or they'll let you know usually that they intend to pursue some type of enforcement action. And so if it is the latter, that an enforcement action is being initiated, then that process really is focused on now negotiating what that looks like, and potentially providing more information to address specific concerns that have come up in whatever it is that they're intending to file. So, generally it's a good idea for companies to voluntarily cooperate with regulators, but not always. There are times that you may want to aggressively push back on that subpoena. Maybe they've exceeded their authority, or it's outside of the scope of the rules that they're looking at enforcing. So a number of different reasons you could do that. So really, if you ever do get a civil investigative demand from a regulator, really the first thing to do is to reach out to an attorney that's knowledgeable in this area.
Yeah, absolutely critical. Having been formerly an in-house counsel who received some of these, I can attest firsthand how important that is to get the experienced counsel in promptly, within 24 hours if you can, because it's these things can move quickly. Um,
Josh was a client before he became one of our partners, so one of the best things ever.
So a couple quick hits as we're rounding out here, and I know we've got a question in the chat I want to make sure we get to here before the end. Just a few things, other privacy things to note. California and New York have passed laws allowing domestic violence survivors to terminate connected vehicle services so that they can't be tracked by their abuser, which OEMs are going to be putting into place We suspect other states may follow along with these kinds of important protections for domestic violence survivors. We're also seeing a lot of states now thinking about what they're sometimes referring to as like neuro data or neurotechnology data as a type of sensitive PI. Montana, for example, is treating it like genetic data. So just something to keep in mind there. Some possible good news, the California Invasion of Privacy Act, which has been a huge thorn in people's sides for the past couple of years. Go back, you'll see in our webinar history a bunch of information about this. I'll just send you there for the details. But the good news is there is a bill pending in California, Senate Bill 690, that would close some of the theories that plaintiffs have been using to bring SIPA cases in what some may argue, and in my personal opinion, not in my official capacity, are kind of trumped up kind of claims around data collection on websites. That has passed the state Senate. It is pending in the state assembly. So if you're in California, call your assembly delegate and if you want to make an influence one way or the other on that bill. Also, we are seeing a proliferation of what are referred to as age-appropriate design code laws. These are laws that impose stricter privacy protections on minors' data, minors being people under the age of 18. Traditionally, privacy laws have really treated 13 and up as if they're adults. We saw in some of the comprehensive privacy laws a sort of middle ground for people kind of 13 through 15 and then started to treat 16-year-olds and up as adults. These laws are now saying, nope, if you're under 18, generally speaking, we're going to put stricter privacy controls in place. These are proliferating. And maybe we'll do a webinar specifically on these later in the year and what they require. But if you deal with, if you're in retail or gaming or sports or tech or anything that deals with potentially people under the age of 18, these are going to be something you're going to want to pay attention to. And then, we talked briefly about federal activity. The FTC continues to push for privacy, specifically around children, to be a congressional focus. We'll see if that happens. Last year, there was a bill that got really close to making it through on enhancing some children's privacy requirements at the federal level. Didn't quite make it. We'll see if this is the year for that. The Take It Down Act was signed by President Trump. This provides certain protections against non-consensual sexual imagery, and even including AI-generated imagery. So this is, I think, an important step towards creating a federal framework to protect people from that kind of conduct. We had seen it in some states. There was kind of a patchwork, but now there's a federal framework for that. And the House of Representatives has stood up a task force to work on a national privacy law. But as Michele and I were discussing earlier, right now, all focus is on other areas. Whether this actually gets to fruition this year, I think is kind of anybody's guess. So Michele, I know you were interested in the future of marketing.
Yeah, what do you think it is, Josh? What's the future of direct marketing with all of these requirements to be able to identify minors, which in and of itself is a very difficult thing, and then to meet all of these do not requirements and protection requirements, and
I think it's a couple things. One, it's using more publicly available information instead of information you're collecting from the consumer or you're buying from a third-party source. That publicly available information does have holes in it, but in most of these frameworks, publicly available information, however that's defined, falls outside the definition of personal information. So it's something to keep in mind there. But also, I think just de-identified and anonymized information is going to become more important. Being able to market to a consumer because that consumer has certain interests, but you have no idea who that consumer is. Now, I'll leave it to the tech folks to figure out how best to implement something like that. But to me, that's where this is going to head, right? There will be, and also just with consumer choice, right? There will be consumers who are okay being targeted for ads from certain businesses, and that'll be fine. But then they don't want to be, tracked and targeted across the board, and being able to honor those consumer choices. So I think it's going to get a lot harder to really target marketing to specific consumers. But there are going to be ways. If there's one thing I know about the marketing industry, it's that creativity is their blessing, and they will find ways to be able to do the work they need to do while honoring these consumer rights.
Yeah, I think that's right. I think it's a really good summary and a good path to provide to companies. Yeah, for sure.
Oh, yeah. So we do have a question in the Q&A that I want to make sure we get to. And Michele, I'm going to direct this to you. I'll read it out here. With the Supreme Court case affecting Hobbs Act deference to the FCC, so going back to McLaughlin from the start, what constitutes prior express written consent for purposes of sending marketing SMS or calls, particularly since businesses have spent a lot of time and resources to get systems e-sign compliant?
Yeah, yeah. So I want to distinguish between prior express consent and prior express written consent. And so all of the efforts that have been made to get into e-sign compliance have to do with prior express written consent, not what I'm talking about. The prior express written consent is the consent that's required for marketing calls using a pre-recorded message, an artificial voice, or an automatic telephone dialing system to cell phones. So that is completely separate. None of that has changed. I guess I should really go back and fully analyze that, but nothing specifically has changed about that that's of note. But with prior express consent, it is the type of consent that you need that isn't required to be in writing. It's just a consumer that is in some way reasonably conveyed their intent to be contacted by you. They're expressing a desire to be contacted. But the TCPA doesn't define that. So what the FCC had said was, if a consumer provides a business their cellular telephone number as a means of being contacted, and they don't subsequently file or request not to be called, then that's prior express consent, and they can rely on that. So think of, like, for instance, you go in to get your oil changed at the local oil change facility. You give them your cell phone number to contact you, and if they're using an auto dialer or a pre-recorded message or those types of things, they could rely on you providing that as prior express consent. Now, the only reason we have that standard is because the FCC said that a consumer providing their cell phone number as a means of being contacted was prior express consent. Now that we have the Hobbs Act is no longer there, we no longer have Chevron deference, which requires the district courts to follow the FCC's guidance. It means that we could have differing opinions in every district court of the United States, which will eventually go to the circuit courts, which is eventually going to end up at the Supreme Court. Now, I don't know if that's going to happen for prior express consent. I think a district court could reasonably infer that if a consumer provided their telephone number as being a means of contact, that they were giving consent for you to contact them. But we all know that when it comes to the TCPA, nothing is normal, nothing is ordinary, and it rarely makes sense. So it's just an area to be careful about. I guess the only reason we wanted to bring it up was just make sure you go back and talk to whoever you work with on your compliance within your company, your in-house counsel, your outside counsel, and just make sure that you go through the TCPA and fully understand what the ramifications of the FCC orders not being required to be followed by the courts.
Yeah.
So did that make sense, Josh?
It does. It does. And I think, right, because prior express written consent was set up, defined in a regulation, as opposed to PEC, which was just this interpretive kind of guidance as to how that works. So it's an interesting situation. Two other questions that we received that I'm going to address just really quickly here. These came in prior to the webinar. One was asking from a BPO perspective, how do you deal with these privacy things? And what I would say is call us. I think there's so many complications. Facts really matter, as I said at the top of the webinar. And so that really requires probably a fulsome discussion. The other one was asking about how privacy enforcement and this privacy enforcement ramp up that we're seeing would impact the healthcare space. And what this really highlights is two things. One, these comprehensive privacy laws generally exempt information that is subject to HIPAA. So in the healthcare space, most of your information is subject to HIPAA, so it would fall outside these laws. And secondly, we didn't really talk about them, but there are a few states now that have consumer health data laws that are separate from their consumer privacy laws or layer on top of them. Most of these consumer privacy laws treat health data that is not covered by HIPAA as sensitive PI. So in the healthcare space, what I would say is the challenge is delineating between HIPAA covered data and data that falls outside HIPAA and ensuring the right compliance regime is applied to the two different buckets. And so with that, I think we've reached our hour. Michele, thank you so much.
Thank you for having me, Josh.
For joining us today. Our information is on the screen. Feel free to reach out with any questions, and thank you all for your time. We greatly appreciate it. Bye-bye.